Law of torts. Definition of tort. Some of the important definitions, which throw light on the nature of tort, are follows. As per Salmond, a tort is a civil wrong for which the remedy is an action for damages, and which is not exclusively the breach of contract or the breach of trust or breach of merely equitable obligation. As per Winfield, tortious liability arises from the breach of a duty primarily fixed the law. This duty is towards the persons generally, and its breach is redressable by an action for unliquidated damages. As per Clark and Linsell, tort is a wrong independent of contract for which the appropriate remedy is a common law action. As per Fraser, a tort is an infringement of right in rent of a private individual giving a right of compensation at the suit of injured party. As per Section 2, M, the Limitation Act, 1963, tort means a civil wrong which is not exclusively a breach of contract or breach of trust. Shortcomings of Winfield's definition. In framing this definition, Winfield is not seeking to indicate what conduct is, and what is not sufficient to involve a person in tortious liability, to distinguish from certain other branches of law. The phrase duty towards persons generally is not adequate to include duties arising from special relationships, like doctor and patient, etc., and to exclude duties arising between guardian and ward or trustee and beneficiary, etc., which fall outside the ambit of law of tort. It is not necessary and distinctive remedy for damages, as the peculiar and distinctive remedy for a tort or breach of duty is fixed by the law and not by the contract, because such damages may be claimed for a breach of trust. The phrase liability arises from the breach of duty may be true at an earlier stage of development of law of tort, but it is not applicable or appropriate to an important category of liability at the present day, for example, vicarious liability of a master for his servant's tort. Thus, the tort can be defined as a civil wrong which is redressable by an action for unliquidated damages, and which is other than a mere breach of contract or breach of trust. An analysis of the various definitions of tort reveal number of elements which can be laid down as tort is a civil wrong. Such civil wrong is other than a mere breach of trust or contract. The remedy for such civil wrong lies in an action for unliquidated damages. The detailed discussion is as follows. Tort is a civil wrong. Wrong can be civil or criminal. Tort belongs to the category of civil wrongs. In the case of a civil wrong, the injured party institutes civil proceedings against the wrongdoer, and the remedy is damages. The injured party is compensated by the defendant for the injury caused to him by another party. Whereas in the case of a criminal wrong, the state brought criminal proceedings against the accused, and the remedy is not compensation. Punishment is provided to the wrongdoer. In a case where the act results in both civil as well as criminal wrong, then both the civil and criminal remedies would concurrently be available. Tort is other than breach of contract or breach of trust. In order to determine whether the wrong is tort or not, the following steps are to be followed. Whether the wrong is civil or criminal. If it is civil wrong, it has to be further seen that whether it belongs to another recognized category of the civil wrongs, such as breach of contract or breach of trust. It is only when the wrong does not belong to any other category of the wrong, that is breach of contract or trust, it is tort, and if the wrong is breach of contract or trust, it is not a tort. However, if the act involves two or more civil wrongs, one of which may be a tort, in such a case, injured party can either claim damages under law of torts or under other breach of civil wrong, for example, breach of contract, but cannot claim damages twice. Tort is redressable by action for unliquidated damages. Damages is the most important remedy for a tort. After the commission of the wrong, it is not possible to undo the harm which has already been caused, but it is the money compensation which can be awarded to the injured party. For example, If there is attack on the reputation of the person, there is nothing which can restore his lost reputation, but money compensation equivalent to harm can be paid to the injured. Unliquidated damages means when the compensation has not been determined previously or agreed by the parties, but it is left to the direction of the court. These are the unliquidated damages which distinguish tort from breach of contract or breach of trust, in which damages may be liquidated, that is, previously determined or agreed to by the parties. The definition given by the Salmon fails to underline the essential characteristics of tortious acts. According to this definition, tort is a wrong, but it does not explain what is wrong, and what kinds of wrong, explaining general features of tort. Moreover, the expression, civil wrong, itself requires explanation. The definition is more informative, but this is also not perfect.